Okay, we're going live.
Okay, bring them in now.
Yes. Okay, we're going live.
Okay, bring them in now.
Yes.
Uh-oh.
YouTube is a little delayed. That's why you heard that. Okay, let me. You ready, Kimberly? Let me know when you're ready so I can start recording. Kim, are you here?
Ready? Yeah, I'm here.
Oh, okay.
I'm
All right. Wait, let me push record. Okay.
This is case number 190025666 Jamal Tawil versus Cheyenne Express Inc. et al.
Okay, council appearances for the record.
Jamal Manson appearing on behalf of Jamal Tawil, the plaintiff.
Okay.
Good morning, Your Honor. Thomas Lurie on behalf of the defendants.
Okay, and Mr. Lurie, this is defendant Cheyenne Express. Wait, yeah, motion, correct?
Cheyenne Express and defendant Altwolo.
Okay, you may proceed.
Thank you, Judge. This is our motion for summary disposition, and it's based on two separate bases, kind of in the alternative. First one is if plaintiff is an employee, then the Workers' Compensation Disability Act bars this action. Now, plaintiff's response acknowledges and argues that he is an independent contractor. While I think that remains a somewhat open question for the court, and it's a question of law for the court to decide whether he's an employee or an independent contractor. When we view the evidence in the light most favorable to the plaintiff, we can continue on to the argument that he's an independent contractor. However, when we look at that argument, then there's no duty to hire, train, or supervise Mr. Tawil, or Mr. Altwolo for that matter, by Cheyenne Express. They're independent contractors. There's no supervision or control over what they're doing at the given point in time when they're on their road. They get a load and they deliver the load to wherever their destination is, and then they bring their load back, whatever load. They go from point A to point B. That's the only thing that Cheyenne Express can control. The manner in which they perform the duties, et cetera, you know, obviously there's the Federal Motor Carrier Safety Act, but that's up to the driver to comply with. And that's basically the arguments in this case.
Okay.
Plaintiff also argued, just very briefly, plaintiff also argued that this was an inherently dangerous activity, but this is a completely unpredictable accident. This isn't a normal motor vehicle accident. Plaintiff overturned this vehicle, which is also results in comparative negligence. So if it's not barred on any of the other bases, I think comparative negligence bars this action altogether as well.
Okay. Mr. Madsen?
Well, the one thing that brother counsel failed to mention is the owner liability statute. The rig that both of those men were driving was in fact owned exclusively by Cheyenne Express. And under 257.401, if they had permission to operate that vehicle on behalf of Cheyenne Express, then they can be held responsible for any negligence by which that vehicle is operated. Also, I would argue that Mr. Tawil was a brand new CDL holder. In fact, he had only driven a truck once for a very short period of time prior to that, even though he obviously was tested and got his CDL. He'd never driven a full load long distance. His assignments were given to him by Mr. Altool. Mr. Altool would call him up, say, be here at this such and such a time and such a date. He didn't believe he had the right to refuse a load at that time. And he also believed he was being trained on how to drive a rig long distance. So strictly speaking, yes, he is technically, it appears he is technically an independent contractor, even though this issue has been raised on multiple occasions. In the prior PIP benefit case, it was raised as a basis for summary disposition, which was denied. It was also, there was a filing of the workers' comp claim by the defendant and of his co-defendant in the prior case, Mimic, to attempt to get workman's comp benefits, which was denied because the magistrate had determined that he couldn't decide whether or not Mr. Tawil was an employee or an independent contractor. So that issue has yet to have been determined by a trier of fact or a trier of law.
Okay, excuse me, and correct, I may have misread or may misinterpret what I read. I thought that there was a workers' comp claim and there was a resolution. It was dismissed, but it was a resolution in terms of was there any compensation under the workers' comp?
No, it was denied because the magistrate indicated that he couldn't be sure that that Mr. Tawil was an employee as defined under the law. As I've said, this has been raised by multiple parties at multiple times, and no determination has ever been made by a judge or a jury.
Okay.
Judge, if I may as well, I think it resulted in a settlement after what Mr. Mattson points out. The workers' comp / PIP dispute settled out, so there was no actual determination under the workers' comp administration.
But was there a settlement on the workers' comp?
No, there was a settlement on the PIP benefits, and I believe it was actually after the settlement was reached on the PIP benefits that Mimic and Cherokee Insurance, which is the insurer for Cheyenne Express, filed on behalf of Mr. Tawil, attempting to get those benefits as a set-off for what the settlement that they had entered into for the PIP case.
So wait, so was there or was there not something paid?
No, nothing was ever
comp?
paid.
Nothing was paid on the comp?
No, again, the one thing that I read, and I can't pull it up right this second, the one thing that I had read that it said that the magistrate was unable to determine if Mr. Tawil was an employee under the definition in the Workers' Comp Act.
Okay, so was it dismissed without prejudice? Or tell me, what was the status?
There was no, it was determined that he was not eligible for workers' comp benefits at that time. I don't know if it was with or without prejudice off the top of my head. Because I have worked for this particular firm on and off for the last year, and I wasn't here for that.
You can see that my position, you can't have it both ways. Either he's an employee or he's an independent contractor. Now,
I apologize.
Yeah, and Mr. Lori, in terms of him being an employee, what's your position, that he was an employee? So we need to flesh out that argument then, if the court's going to make a determination.
Sorry to interrupt there, Judge. The reason I set forth that argument was because in order to have a duty to hire, train, and supervise any person, they must be first an employee to establish that duty. So the argument follows, if he is an employee, because he's arguing that he's owed a duty to be hired, trained, supervised, and also that Mr. Eltwell should be hired, trained, and supervised, then he is implicitly arguing that they are employees.
Okay,
If-
let me stop you right there. Mr. Madsen, what's your client's position?
Our client's position, and we attached several items. And in fact, Cheyenne has also attached items to prior motions, the prior motions that I discussed earlier. There's paperwork indicating that as far as they were concerned, he was an independent contractor. Now, whether or not he understood what that actually meant, I can't speak to that because I don't know. His prior experience before going to trucking school was managing a gas station.
Okay, but
So
now,
he may or may not have fully understood what his position was, but according to the paperwork, as much as I've seen and read, everything seems to indicate that it was the intention that he be an independent contractor. But most independent contractors own their own rigs and take care of their own insurance and do all their own stuff for their truck. He didn't own a truck. He didn't have the funding to purchase a truck at that time. So he was basically tagging with Mr. Altool. And it was his understanding that that was his period, that he was going to be being trained up to handle over the road long hauls, which he has never been trained for before.
Mr. Lord? Mr.
I'm
Lord,
not sure. Yes, Judge. Sorry, I'm
you're
taking a
thinking,
moment to think about how to respond because plaintiff is essentially arguing that he was a certified driver, that he had a CDL, that he got his training. That CDL permits you to be an over-the-road truck driver with no restriction. There are no restrictions on his license. He was certified to drive this truck by himself. Mr. Altool didn't even need to be there to properly allow this man to drive this vehicle. He did not need to be there. Was he there? Yes, he was there. And based on Mr. Tawil's testimony, the only person who could have stopped this accident was Mr. Tawil. He could have kept going. He could have woken up Mr. Altool. He knew he was taking the ramp too fast. He readily admits that, he made a mistake and that he went off, and he tries to blame that mistake on Cheyenne Express and Mr. Altool when he himself made the mistake. And he's a fully certified and licensed driver. Whether or not he's most experienced person in the world is irrelevant. If he is, as we are saying, an independent contractor, and he's representing to Cheyenne Express that he's a certified to drive this truck, then the fault lies only with Mr. Tawil.
Okay. I would point out, however, that they were on a route that Mr. Tawil was not familiar with, and Mr. Altool, from what I understand, was. Mr. Altool had shut off the navigation system because he didn't want to be. Please don't interrupt me, sir. He had turned off the navigation system because he didn't feel he needed it, and before he decided to take his nap, he didn't bother to turn it back on, and Mr. Tawil was not permitted independent access to that particular system. So what happened was he didn't realize that he was approaching the interchange until it was too late, and he didn't have an opportunity to brake properly or get onto the exit ramp properly, and he didn't want to miss his change off. He's an inexperienced driver, regardless of his CDL. It's similar in many respects to when, and I know that we're not truck drivers, but when a lawyer is handed their legal license, very often if they're employed by someone else, they're not allowed to go into court by themselves. They're given an opportunity to train and learn in the field what they weren't taught in law school. So I mean, I know it's not a precise match, but it's reasonable for him to presume that he was going to get additional training on certain things that he hadn't seen in school, and he believed firmly, whether it's written on paper anywhere or not, that's what he was getting.
Judge, I'd just like to point out to the GPS thing. The GPS navigation system was not turned off according to Mr. Tawil. It was muted. The sound was off. So there wasn't voice guidance on the GPS system. So it wasn't saying you're approaching your exit in 0.5 miles, or for example, Mr. Altool, according to Mr. Tawil, Mr. Altool doesn't need it because he's more experienced. Mr. Tawil says that he prefers to drive with that on. However, Mr. Tawil also testified that he did not ask Mr. Altwil to switch the modify the GPS to turn the sound back on before he started driving the vehicle, which, as a driver, as a certified commercial driver, he is responsible for making sure everything, when you get in your car, you make sure your seats are buckled and that your mirrors are adjusted exactly how you prefer it, and that all the settings in your car are how you prefer it. So if he preferred the GPS system to be on, he should have asked Mr. Altwool to turn the voice navigation on before he started driving his vehicle. And I think that argument also inherently admits that Mr. Tawil knew that he was going to miss the exit anyways. And it's because he wasn't paying attention to his GPS navigation system, even though there wasn't sound on.
Okay, well, let's, I think we can do one thing. I think that there's a sufficient enough information to confirm that Mr. Twill was not an employee. So then we'd look to him in terms of his duties and responsibility due to the fact that he was a certified driver. He had a CDL. He had no restrictions on his license, and hopefully that he had had his training before he took this job. And I think it's clear that at that time, Mr. Altool was just doing a ride along with Mr. Twill to ensure that everything was going proper. So we know that because Mr. Twill was an independent contractor, there's no duty to hire, train, or supervise, that he was to come to Cheyenne Express with proper training. Granted, he may have hadn't had his license for a long time, but it was still his responsibility became to them to have the proper training, that they weren't going to give him any overroad training. Was it an inherently dangerous condition? No, truck driving isn't inherently dangerous. A driver just has to take the appropriate steps to ensure that the vehicle is operated properly. The comparative negligence, we know that this was definitely a one vehicle accident. There wasn't anybody else involved. And being the driver of the vehicle, Mr. Twill would be wholly responsible for any actions that resulted of him driving the vehicle. And I think the last thing that you discussed was the owner's liability statute. Was it 257.401? Is that correct?
That's correct.
Okay. And in terms of that, the negligence in my mind would be negligence against somebody else. And here, as we've asserted, that there's a single vehicle accident upon which Mr. Twill was driving. So I really don't see that the owner's liability statute applies here. And the court does take the evidence in the light most favorable to the non-moving party. And that being said, as I indicated, there's nothing to assert that he was an employee, so we look to him as an independent contractor. And there wasn't any duty to hire, train, or supervise based on the fact that he was an independent contractor. And as the court asserted, just driving a truck isn't inherently dangerous. And I don't, if there was a truck where you had some flammable material or something to that effect, maybe it could have been deemed inherently dangerous. But just driving a truck, the court doesn't find that there's any basis for the driving of a truck to be inherently dangerous. And as I indicated, the only thing, the comparative negligence, unfortunately, the responsibility was totally with Mr. Twill. Did I leave anything out?
I don't think you left anything out.
Right, so I just wanted to make sure I covered all the bases. And as I indicated, taking evidence in light most favorable to the non-moving party, there's a sufficient basis even here for the court to grant summary disposition on all counts. Other than, and the court made the determination that he was not an employee because there's nothing to support him being an employee. Okay, and Mr. Louis, we'll look for you to submit an order to the court.
Yes, Your Honor.
Okay. And then that there's, and it's my understanding that the PIP was previously resolved, correct?
Yes,
Correct.
Okay,
this is not a PIP case at all.
okay, all right, so this will totally resolve the third party action. So Mr. Lord, we'll look for a stipend order of dismissal in addition to the granting of the summary disposition.
Yeah, so you want me to submit a separate order of dismissal?
No, but you can put it on there, but I'm just saying, just make sure that the stipend, that the order of dismissal is also articulated on the granting of the summary disposition.
I will note that. Thank you, Your Honor.
Okay, anything else, gentlemen?
No, Your Honor, thank you.
Thank
No,
you. This
Your
concludes this hearing. Thank you.